My name is Guido Noto La Diega, and I'm an associate professor of intellectual property and privacy law at the University of Stirling. And I'm here with Cristiana Sappa.
Ladies and gentlemen, good morning. I'm Cristiana Sappa. I'm assistant professor of business law at IESEG School of Management, Lille and Paris. And today I'm very pleased to be here together with Guido to present to you our research on the Internet of Things, and in particular to focus on some intersection of data protection and trade secrets. With Guido, we have spent some time very recently to investigate it on the trade secrets related aspects and data protection related aspects in the IoT, in the Internet of Things, and to some extent artificial intelligence world, in order to understand whether and how consumers might be empowered. More precisely, we're going to present today some first tips of our work, starting from the framework of the research. Some introductory remarks will be presented as well, and then we will shift to the data, to the trade secrets and the IoT related aspects, and to the interfaces between trade secrets and personal data aspects in such a ecosystem, before presenting you also some conclusions.
Thank you, Cristiana. Obviously, we have very limited time here, but to give a sense of the data protection issues that are related to the Internet of Things, and in particular to what we call data appropriation, we can have a look at Amazon Echo and Alexa. Their privacy policy doesn't really tell us which data Amazon is processing and collecting about us or for which purposes. They only disclose, quote, the types of information that they gather and examples of information collected. And we don't really know what this company is doing with our data, and we don't really know if we can access that data that the company is trying to monopolize and appropriate, also using trade secrets. And often this data is very valuable. One needs only think that, for instance, Amazon stores our voice recordings of the interactions that we have with Alexa and Echo, and that's very, very important information about us. What our reflection was that although traditionally consumer law could offer some redress to consumers that are affected by IoT data appropriation practices, however, like consumer laws are not necessarily fit for purpose. The main laws that we have in mind are the pre-contractual duties to inform under the Consumer Rights Directive, and these are not fit for purpose in the IoT because of the issue of the lack of interfaces, or for instance, the very small displays that many of the smart devices have, which make communicating information particularly challenging. Equally, the Unfair Term Directive and the non-binding nature of unfair terms is not fit for purpose because it's focused on the contract, whereas the forms of manipulation and the forms of like consumer damage that occur go well beyond the contract. And finally, the Unfair Commercial Practices Directive is unfit because it's focused on the economic aspect of a commercial transaction, of a consumer transaction, and that's whereas the ways that IoT companies appropriate our data and abuse and use their data power go well beyond an economic transaction. And therefore, we wondered what other ways we can have to re-empower consumers in these sorts of scenarios, because obviously we could use competition law, but competition law is a more kind of ex post type of measure, whereas we wanted to reflect on whether there are certain ex ante mechanisms that we can rely on. Trade secrets, on the face of it, don't really offer much in the sense that they are a set of quasi intellectual property rights, not properly intellectual property rights, but they are designed to favor market operators' interests. but we will see that within them, actually, there are certain breathing rooms, the trade secrets exceptions, that could be used to empower consumers. And on the other hand, we have the GDPR and its emphasis on data control and data access and transparency. And so we thought that perhaps a holistic approach of integrating these two bodies of law could offer some recourse to consumers affected by data appropriation in the Internet of Things. Over to you, Cristiana.
Thank you, Guido. The fact of studying trade secrets and data protections limits and limitations comes also from the fact that some private order initiatives that might exist as exempt measures are there, but they are not mandatory, and therefore they do not offer a very harmonized or homogeneous solution to that. So focusing on trade secrets, we all know that trade secrets is, of course, a legal form of protection that is enabling market operators to keeping strategically and commercially valuable information undisclosed, providing them a competitive advantage. And any leak of such an information would create a potential estimated damages to such market operators. And this is why they have an interest in maintaining such an information undisclosed. There are, of course, measures at the rules at the international level that are aimed at protecting trade secrets that have been implemented at the regional level, such as in the European Union via directive. And the focus of our research is in particular how such a directive has been transposed into some states, in particular France, Italy and UK, and we selected these countries because of the provenance of Guido and I, and because of the places where we are established. And the comparative analysis led us to some interested aspects as well. Now, what is the information that is covered by trade secrets? There's quite a lot of information, actually. And we are talking about information and knowledge that is able to meet some specific requirements. And in particular, we're talking about all the information that the market operator is maintaining as a secret, as undisclosed, via appropriate implementation of technical, organizational, and contractual barriers. And if you look at the slide that we're showing, there's these barriers are underlined: contractual, organizational, and technical, because this is really the core of the debate in the upcoming future. Because there are many aspects that have to be underlined in relation to this, in particular in the IoT and in the AI world. Now, other papers have already argued that trade secrets do exist in the Internet of Things world, and they cover a lot of information that is also produced and generated by sensors and devices that are interacting in the trade secrets world. And therefore, also we are also referring to the information produced by the Dash button and the Echo, for instance. This is particularly justified by the principle of non-discrimination, because it would make no much sense to discriminate between this kind of information and other kinds of information in other industries. If we have a close look at all the information that is circulating and generated in the AI and IoT ecosystems, we can also see that there's a lot of databases, and sometimes databases are composed of non-valuable information as such, but the set of information, of data obtained by aggregating data initially gathered by humans or artificial techniques may also be covered by trade secrets. So this is extending pretty much the scope of application of trade secrets. So the next question would be, what is left out from protection, since a lot of information is covered by such a quasi intellectual property right, which is favoring the market operator interest. Well, there's the information that what is left out is the information that basically does not meet the requirement. Therefore, mention the requirement to comply with to access the trade secret subject matter protection. There are all the independent discoveries and reverse engineering that are operated by third parties. And there are also all the initiatives that are falling under the exceptions and limitations of trade secrets, in particular those that are provided by Article 5 of the Trade Secrets Directive. Now, all this information is in principle open to the other market operators, so to the competitors, but also to the consumers. And in particular, if we pay attention to the exceptions and limitations of Article 5 of the Trade Secrets Directive, we'll see that there are a couple of exceptions that are referring to the disclosure and use of trade secrets for exercising the right of freedom of expressions and information, which includes the freedom of press, but also the use of disclosure of some trade secret protected information for the purpose of protecting a legitimate interest. Now, the effort we made in the research is to see how this was interpreted in France, where the transposition was more literally and therefore there's quite a big change in the national law for transposing such measures. Also, we had a look in Italy where these exceptions were not transposed because the principles, the case law is already covering these exceptions, and we paid also attention to what's happening in the UK. Where the situation is a little bit more complex, but basically the national law is in compliance with the EU law. The idea is that all the exceptions and limitations, no matter how they were transposed at the national level, where the technique to transpose them at the national level, these exceptions and limitations provide some way to to give more transparency and to more power to consumers, and consumers are one of the stakeholders that have to be taken into account in the overall pictures. So the idea, the message that we give in the research is that we have to read all the provisions of the Trade Secrets Directive in light of the principle of proportionality, so that there's a balance between the different interests of the stakeholders. Notwithstanding this very balanced reading, we think that there might be something that is still missing, that the trade secrets exceptions and limitations, or limits more broadly speaking, might not be enough to ensure the empowerment of consumers' interest. And therefore, we might need to search somewhere else and to complement these provisions with something else. What is this something else? Data protections related principles. And here I give the floor to Guido again.
Thank you. And that's where our collaboration comes from, really trying to understand how these two different legal bodies can really complement each other. So we started by, to understand the interfaces between trade secrets and personal data, we started by looking at the Trade Secrets Directive that in theory declares that there is no conflict between trade secrets and data protection, and that the Trade Secrets Directive does not adversely affect the rights and obligations under the GDPR, and that it respects the right to protection of personal data. But we think that despite this sort of statement, conflicts between trade secrets and personal data do and will occur. So it's important to understand how these conflicts can be governed, but those were only recitals, whereas the only binding provision in the Trade Secrets Directive that actually refers to the interface between trade secrets and personal data is Article 9, paragraph 4, whereby the processing of personal data in the course of legal proceedings relating to the unlawful acquisition, use, or disclosure of trade secret must comply with the GDPR. This might be interpreted as meaning that the GDPR binds trade secrets holders only when it comes to legal proceedings. However, we do believe that IoT companies that use trade secrets to appropriate personal data of users have to comply with the GDPR throughout the life cycle of the data. And this can be seen partly through the exceptions and limitations, as Professor Sappa showed, but also can be seen within the body of data protection law. Indeed, like the Trade Secrets Directive, the GDPR does not expressly regulate the interplay between these two legal bodies. However, there is an interesting recital 63, that whereby the right of access should not adversely affect the rights or freedoms of others, including trade secrets. This provision, this recital, better said, has been seen as meaning that IoT companies and more general trade secrets holders can simply reject subject access requests mentioning trade secrets as the justification. However, we claim and argue that that's not the correct interpretation, that actually the trade secrets cannot justify a blanket refusal to grant access to personal data. And this is based on three arguments. Starting off with the first one, the GDPR itself clarifies that the result of trade secrets considerations should not, and I quote, should not be a refusal to provide all information to the data subject. According to the Article 29 Working Party, this means that controllers, like IoT companies, cannot rely on the protection of their trade secrets as an excuse to deny access or refuse to provide information to the data subject. So what does it mean that the right to access cannot adversely affect the trade secrets? A meaning of this could be the following. Under the GDPR, companies, data controllers are encouraged to put in place automated remote access systems to allow remote access to user personal data. However, such a system would be inconsistent with the reasonable steps that the trade secret holder has to take. So a first meaning of Recital 63 would be that IoT companies holding trade secrets don't have an obligation to put in place an automated remote access system to grant access. However, they have to grant access on a case-by-case basis. So the first point is keeping in mind that IoT companies, have to endeavor to distinguish between that data that is actually covered by trade secret and all the rest of the data. They cannot simply claim secrecy, trade secrecy, as a justification not to grant the right to access. The second point is the following. The right to access is actually 4 different rights. It's the right to confirm that data is being processed, the duty to grant access to key information about the processing, including the purposes of the processing, the obligation to grant access to the data, and the right to obtain a copy of the data free of charge. Now, if we go to Article 15 of the GDPR about the right of access, it says that only the right to obtain a copy should not adversely affect the trade secrets. So it's not like IoT companies can simply reject the requests to access. They only have a waiver when it comes to the right to obtain a copy. So as a consumer, I won't have a copy of my data, of that data that is covered by trade secrets. However, these companies have an obligation to release a copy of the rest of the data. They have to confirm that data is being processed, including for purposes of trade secrets and data appropriation. They have to grant access to key information, including the purposes of the processing, and more importantly, they have to grant access to all the data, we argue, including data that is covered by trade secrets, although only in view-only mode and with appropriate safeguards. And the third argument is that if we look, we looked at the right to data portability, that is the right to receive one's personal data in a structured, machine-readable format. Essentially, I have the right in general to obtain all my data in a digital form that can work with another service provider. And under the GDPR, Article 20, Paragraph 4, this right shall not adversely affect trade secrets and other rights and freedoms of others. Unlike the right of access, this right, portability, can be excluded as such if it means to harm an IoT company's trade secrets. However, IT companies have to isolate the requesting data subject's personal data and facilitate its portability. So again, a blanket refusal to ensure data portability will not meet the requirements of the GDPR. So in conclusion, when it comes to interfaces, the right to obtain a copy and the right to portability are the only data subjects' rights that can be to some extent compressed when it comes to data appropriation, IoT data appropriation, and trade secrets. However, IoT companies cannot invoke their trade secrets to shield their data appropriation practices from the other data subjects' rights, and we believe that these other data subjects' rights can really play an important role in empowering consumers, and when it comes to these data appropriation practices. And in particular, there is a lot of potential when it comes to the right to be informed and the right not to be subject to automated decisions. For reasons of time, we cannot go into much detail on this, but perhaps during the question time, we can discuss it further. And I will give the floor to Professor Sappa for the conclusions.
Yes, in a nutshell, basically, we know that in the IoT world, the personal data are appropriated by private companies by multiple means, including trade secrets, and there's a palpable tension between data protection laws and trade secrecies, and there's not sufficient evidence to conclude that one regime will always prevail over the other. So all these have to be decided on a case-by-case basis. And we really focus on some trade secrets, limits, and data protection considerations that can be invoked to counter all the opaque data appropriation practice of the IoT companies, such as the big platforms like Amazon's, but not only Amazon's. So there are more details in the paper, in the draft, in the research, but the overall message is that we should use an holistic and probably non-conventional approach for empowering the consumer protections that integrates trade secrets, exceptions, and data protection rights. So that IoT consumers in particular are more empowered thanks to the opening of the black box created by opaque data appropriation practices. Should you have any questions, we would be very happy to answer them. Thank you for your attention.